Hare Krishna. Welcome to Tax YouTube channel. This is C.A. Rohanar, being a practicing chartered accountant based in Mumbai. Also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says. And today we are going to discuss two important cases reported to High Court. One is related to Section 263 revision and other is related to recovery procedures by TRO. So let's dive into it. Let me allow to share my screen. Yes. So today's first case, Tripura State Electricity Corporation Limited versus Principal CIT, High Court Tripura, date of order 14th August 2025 and relevant assessment year is 2013-14. Let's understand facts of the case. Assessee, state-owned electricity distribution company. Assessment completed under section 143 subsection 3. Subsequently, principal CIT invoked section 263, that is revision. So allegation was assessment order was erroneous and prejudicial to the revenue. AO failed to properly examine certain claims, typically depreciation, expenditure allowances, and revenue recognition. So assessee challenged the revision before the High Court. So let's see what was the issue under consideration. So whether revision under section 263 is valid when assessing officer has already conducted inquiry and PCIT merely holds a different opinion and nothing more than that. So let's see relevant legal provisions. Here, section 263, revision of orders prejudicial to revenue and conditions. Order must be erroneous and prejudicial to the revenue. And judicial principles, lack of inquiry versus inadequate inquiry. Very important. Lack of inquiry versus inadequate inquiry. And doctrine of possible view. So let's see what are the grounds of appeal by the assessor. So AO had called for details, examined the records, and applied his mind is what contended by the assessee. And also PCIT didn't, what other contention is PCIT didn't demonstrate how order was erroneous and attempted substitution of opinion. So hence revision is without jurisdiction is what contended by the assessee. So let's see what High Court observed and held. Court observed here that AO had conducted inquiry. Once inquiry is made, adequacy cannot be questioned under section 263. Please note down this. Once inquiry is made, adequacy cannot be questioned under section 263. Distinction emphasizes that inadequate inquiry is not equal to ground for revision. Lack of inquiry is equal to valid ground. Okay, inadequate inquiry is not equal to ground for revision. Lack of inquiry is a valid ground. So PCIT failed to show any specific error in law or fact. So revision power is not appellate power. So held that invocation of 263 was invalid and revision order quashed. So let's see what principles laid down by this case. Two conditions must coexist under section 263, that is erroneous order and prejudicial to the revenue. So if AO adopts one of the possible views, no revision, correct? So revision cannot be based on change of opinion. That is the main point of the case. Adequacy of inquiry is not examinable. Revision power is supervisory and not appellate. Okay. So moving further, today's case 2. Manjulaben Mafatlal Shah versus TRO. High Court is Bombay High Court. Date of order very recent, 17 February 2026. Assessment year is not applicable here. So let's see what are the facts of the case. Assessee, individual taxpayer. Proceedings initiated by tax recovery officer, that is TRO. Action taken, that is attachment or recovery proceedings initiated, possibly without the proper notice or adjudication. So assessee approach to High Court via writ petition. So let's see what was the issue under consideration. Whether recovery proceedings by TRO are valid when proper procedure not followed and principles of natural justice also violated. So let's see what are the relevant legal provisions. Section 222 to 232, that is recovery of taxes dues. Second schedule to Income Tax Act 1961 governs attachment, sale of property, recovery procedure. Constitutional principles, Article 14, that is fairness and natural justice is what involved here. So let's see grounds of the so recovery initiated without proper service of notice, without opportunity of hearing also. So TRO didn't follow mandatory procedures need to be followed and action was arbitrary and excessive is what contended by the assessee. So let's see what High Court observed and here. So Bombay High Court emphasized that recovery powers are what drastic in nature, hence must be exercised strictly as per law. And mandatory compliance, that is proper notice, opportunity to object and reason order. These are the mandatory, need to be complied it before the very any actions you need to be taken. So any violation of it renders what proceedings void ab initio. So hail that recovery proceedings set aside and matter remanded or directions issued for fresh action in accordance with the law. So let's see principles laid down by the case. Strict adherence to the procedure in recovery matters. Natural justice is mandatory. TRO cannot act mechanically, and attachment without due process is what invalid. So tax recovery is not equal to arbitrary coercive action is what we can say we had drawn the principles from the relevant cases. So key takeaways from both the cases discussed today are power of tax authorities is not absolute one. Courts increasingly emphasize what due process, reason orders, and fairness. So, two strong doctrines emerge: possible view doctrine, that is assessment at assessment stage, and natural justice doctrine, that is at a recovery stage. So, that's it for today. Thank you. Thank you so much for patient hearing. If you have any questions, observations, suggestions, then do let me know via WhatsApp, email, or you can also comment below the video. If you are not yet subscribed Tax Guru YouTube channel, then do subscribe for it for latest updates and video series like this. Hope you are gaining the valuable knowledge from all these updates and video series we are conducting on Tax Guru YouTube channel. Thank you. Thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.